Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. As I have started with this series on the Banking Law and Negotiable Instrument Act, and I have discussed certain important questions relating to the banking law in the previous videos. Today in this video, I am going to discuss with one more important question, that is application of the Banking Regulation Act as well as the winding up of the banking companies in detail. This question has been asked for many times in the previous year question papers. Talk about the winding up. Provisions relating to the winding up of the banking companies are contained in Part 3 of the Banking Regulation Act. And jurisdiction and suspension of winding up of the banking companies that is conferred on the High Court. Section 38 to 44 of the Banking Regulation Act lays down the provisions for the winding up of the banking company. Under Section 38 of the Banking Regulation Act, the High Court has been given power to order the winding up of the banking company if banking company is unable to pay its debt. Second, if the affairs of the banking company are conducted in a manner detrimental to the interest of the depositors, then RBI may apply to the High Court for its winding up on this ground. So the RBI may make an application for the winding up of the banking company under Section 38 if it has failed to comply with the requirements as to the minimum paid up capital and reserves as laid down in Section 11 of this Banking Regulation Act, or it has the reason of Section 72 of the Banking Regulation Act, this entitled to carry on the banking business for the want of license. Next one is, it has been prohibited from receiving fresh deposit by central government or RBI by an order under Section 35 Clause C and under Section 42 Clause 34 of the Reserve Bank of India Act. If it has failed to comply with the requirements of the Act and continues to do so even after RBI calls upon it. Next one is, if in the opinion of RBI, a compromise or arrangement sanctioned by the court in respect of the banking company cannot be worked satisfactorily with or without the modification. Next one is, if the information and statement received from the banking company discloses that it is unable to pay its debts. Next one is, the continuance of the banking company is prejudicial to the interest of the depositors. Also Section 38, it provides that without the prejudice, the provisions of the Section 34 of the Banking Companies Act of the Companies Act 1956, a banking company shall be deemed to be unable to pay its debt if it has refused to meet the lawful demand made at any office or branches. In the lawful demand made at any office or branches. In the case of Doraswamy Iyer versus Coimbatore ESN Limited, it was held by the Honorable Apex Court that the non-payment of the debt by a company about which there was a dispute and the company honestly believed if it is not bound to pay would not amount to the company being unable to pay its debt. Section 38 Clause A provides that every High Court has a court liquidator attached to it for the winding up of the banking company. In special cases, the RBI and the State Bank of India or any other notified bank or any individual can be appointed as official liquidator on an application by RBI or otherwise. Under Section 38 Clause A, the RBI liquidator shall become the official liquidator of the banking company unless central government has directed to the contrary. Section 40 provides that High Court shall not stay any proceedings concerning the winding up of a banking company unless it is satisfied that an arrangement has been made whereby the company can pay its depositors in full as their claims accrue. यदि हम किसी भी कंपनी के वाइंडिंग अप की बात करते हैं तो इससे संबंधित प्रावधान बैंकिंग रेगुलेशन एक्ट के सेक्शन के पार्ट 3 के अंदर और सेक्शन 38 से लेकर 44 तक दिए गए हैं और इसके संबंध में किसी भी कंपनी को वाइंडिंग अप करने के लिए या सस्पेंशन के करने का जो जुरिडिक्शन है वो हाई कोर्ट के ऊपर कन्फर किया गया है। सेक्शन 38 के अनुसार हाई कोर्ट किसी भी कंपनी के वाइंडिंग अप का ऑर्डर दे सकती है यदि कोई भी कंपनी अपने डेब्ट्स को पे करने में अनेबल पाई जाती है, असमर्थ पाई जाती है। यदि किसी भी बैंकिंग कंपनी के जो अफेयर्स हैं वो इस तरह से किए जा रहे हैं कि जो डिपॉजिटर्स हैं उनके इंटरेस्ट को वायलेट करेगा, तो ऐसी स्थिति में आरबीआई हाई कोर्ट के अंदर उस कंपनी के वाइंडिंग अप के संबंध में अप्लाई कर सकती है। आरबीआई किसी भी कंपनी के वाइंडिंग अप के संबंध में सेक्शन 38 के तहत एप्लीकेशन फाइल कर सकती है यदि वो कंपनी मिनिमम पेड अप कैपिटल की जो रिक्वायरमेंट है उसको पूरा करने में असमर्थ पाई जाती है। सेकंड, यदि सेक्शन 22 के तहत बैंकिंग कंपनी वो अपना का जो लाइसेंस है वो लेने में असमर्थ है। थर्ड वन इज इट हैज बीन प्रोहिबिटेड, यदि कोई भी बैंकिंग कंपनी यदि उसको किसी भी सेंट्रल गवर्नमेंट के द्वारा फ्रेश डिपॉजिट लेने से इनकार किया गया है और उसका ऑर्डर सेक्शन 38 क्लोज 4 और सेक्शन 2 क्लोज 34 रिजर्व बैंक ऑफ इंडिया के तहत पास किया गया है, तो ऐसी स्थिति में आरबीआई उसके वाइंडिंग अप के लिए हाई कोर्ट में अप्लाई कर सकती है। या फिर आप ये कह सकते हैं कि इट हैज़ फेल्ड टू कंप्लाई विद द रिक्वायरमेंट्स ऑफ द एक्ट, यदि वो उस आरबीआई एक्ट के जो रिक्वायरमेंट्स हैं उसके साथ कंप्लाई करने में, उसको पूरा करने में असमर्थ है। दोयास्वामी अय्यर वर्सेस कोयम्बटूर के वाद में यहाँ पर कंपनी के द्वारा ये कहा जाता है कि वो उस डेप्ट को पे करने के लिए बाउंड नहीं है, तो वो कंपनी अपने डेप्ट्स को पे करने में असमर्थ नहीं है, ऐसा आप नहीं कह पाएंगे। सेक्शन 38 क्लोज ए के तहत हाई कोर्ट ये कहा है कि हर कंपनी के लिए एक लिक्विडेटर अटैच होना चाहिए। जो स्पेशल केसेस हैं जहाँ पे आरबीआई, एसबीआई या कोई अदर नोटिफिकेशन के द्वारा कोई भी ऑफिशियल लिक्विडेटर अपॉइंट किया जा सकता है। नाउ द प्रोविजंस रिलेटिंग टू द वाइंडिंग ऑफ द बैंकिंग कंपनी आर, फर्स्ट वन इज ऑफिशियल लिक्विडेटर मस्ट सबमिट ए प्रिलिमिनरी रिपोर्ट टू द हाई कोर्ट within 2 months from the date of the winding up order on the assets and liabilities of the banking company. Second is, the official liquidator must give notice to the preferential claimants and the secured and unsecured creditors within 15 days of the winding up order. Third one is, under section 42, High Court may dispense with meeting of creditors, contributors or with appointments of the committee of inspection where it considers that no object will be secured. Next provision is, under section 43 of the act, every depositor of the banking company shall deemed to have been filed his claim the amount shown in the book to his credit, and such claim shall be deemed to have been proved. Every depositor will be deemed to have been filed and proved his claim for the amount shown in the book at the banking company unless and until there is reason for the doubt. And the next provision is, after making the preferential payment under section 530 of the Company Act, the liquidator shall pay within 3 months of every depositor of the saving bank account. Also, where the company holds a license under section 22, it cannot wound up voluntarily under RBI Act. If the RBI certifies that company is able to pay all its debts in the full as they accrue. That provision is provided under section 44. Next provision is, in the case of voluntary winding up of a banking company, the High Court may make order that voluntary winding up shall continue subject to supervision of the court. Next provision is, High Court may on its own or on the application of the Reserve Bank of India order the winding up of the banking company by the High Court where the company is being wound up voluntarily and at the stage of the proceeding company is not able to meet its debts as they accrue. In the opinion of the High Court, such winding up cannot be continued without detrimental to the interest of the depositors. Provision, that is, court will not sanction a compromise or arrangement between the banking company and its creditors or members unless certified in writing by the Reserve Bank of India or not detrimental to the interest of the depositors and not capable of working. That provision is provided under section 45. And the next provision is, no banking company shall be amalgamated with any other banking company without the previous written sanction of the Reserve Bank of India. These are the certain provisions relating to the winding of the banking company added by the Banking Regulation Act. Talk about the application of the Banking Regulation Act 1949. To avoid the confusion, first we must bear in mind that there are 3 types of banks. First is banking companies which are not nationalized. Second one is nationalized banks including RBI and 20 nationalized other banks and the regional rural bank and subsidiary banks. And the last type of bank, that is cooperative banks. The whole of the Banking Regulation Act 1949 except section 56 applies to all banking companies which are not nationalized. Only the certain sections of the act which are applicable to the nationalized banks. According to Section 51, Section 3 Clause 5 and Section 20 of the Act describe certain sections which apply to the nationalized banks. Also, the Act applies to all the cooperative banks, the paid-up share capital of which is not less than 1 lakh rupees. And the Act applies to all the state cooperative banks and central cooperative banks also. So this was all about the application of this Banking Regulation Act. And if you have any doubt, then you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.